SJC-12787, Morgan Helfman v. Paris Sanders and others.
Mr. Itzkowitz? Whenever you're ready. Good morning.
May it please the court. Mark Itzkowitz, and with me Ken Colpan for the plaintiff Morgan Helfman. Your Honor, back in 1983, this court established the duty of care for colleges, writing in Mullins versus Pine Manor College, colleges must act to use reasonable care to prevent injury to their students by third persons, whether their acts were accidental, negligent, or intentional. And they based that decision in part on Carey versus New Yorker of Worcester. Your Honor, this is a case of institutional negligence. Northeastern voluntarily created programs, drafted policies, hired and ostensibly trained personnel to address a major social problem, which was not only foreseeable, but which the colleges actually foresaw.
Could you tell me what it is that you're saying that the duty is upon the Northeastern? What is Northeastern's duty here? I don't understand the scope of the duty that you're trying to
The scope
impose.
of duty, Your Honor, is to implement the policies that Northeastern actually drafted and created.
So you're saying it's assumed duty?
It's an assumed duty, and it's a duty that is based on Mullins, which was not solely an assumed duty, although that was a major part of it. But it's a duty based on the student-university relationship.
And what is the duty that you say that they've assumed?
The duty is to act to use reasonable care to prevent injury, as I indicated. Now, in this case,
Prevent injury. What do you mean, injury?
the injury
Is
in
it
this
the
case,
underage drinking that's the problem, or is it the sexual assaults that are the problem?
both are the problem, Your Honor. It's the interrelationship between the two that are the problem. And that is a problem that was well known to Northeastern. That is a problem that's known to the college community. It's a problem that the Superior Court ignored in this case. The problem, Your Honor, the decision by the trial court ignored the entire body of social science research, which has found overwhelmingly that approximately 55% of college campus rapes involve the misuse of alcohol. Some of the studies find that percentage as high as 90% plus. The decision ignores the social science and criminal justice research, which finds that 1 out of 5 college women...
But what is that? And I understand what the research says, but does that mean they have a duty to prevent all drinking at college? I mean, I'm trying to make an understanding of what you're saying.
Well,
the same question Justice Link said. What is... Hone in on the duty, because are you saying that Northeastern had a duty to prevent all drinking at Northeastern?
Well, underage drinking, or what?
Underage drinking at Northeastern.
Ideally, they had a duty to prevent all underage drinking on campus. They are not going to be successful in that, and we recognize that. So what we have here is a situation where, recognizing that they're not going to be 100% successful on that, they have, in fact, created programs and policies, and they've hired and ostensibly trained and supervised personnel to enforce those and implement those programs and policies to at least do a couple of things. One is stop the drinking where they can stop it. Now, they're not going to be able to stop all drinking. We recognize that. But secondly, when, in fact, they're confronted with evidence that there is a problem because of drinking, to take action to address the problem. So, for example...
What is the problem?
I'm sorry, Your Honor?
What is the problem that you want to have addressed? The underage drinking, or what?
It's the underage drinking, it's the sexual assault, it's the relationship between the two. Okay, I don't think that in this context, Your Honor, that can properly be separated.
But so, could you be more specific? I mean, I'm trying to figure out what is the duty, if there is any, and what is the reasonable measures that can be done here? Are you saying when she's terribly intoxicated or incredibly, whatever the word, she uses the word herself, she's very intoxicated, she's throwing up in the RA's bathroom. Do they have a duty at that point is that what the duty is? Or is the duty this more amorphous duty you're describing to prevent drinking and sexual assault? I'm just, because this is a case between, one individual and Northeastern. I'm trying to understand what the duty is.
Sure.
But by the way, the case law is very unclear what this duty is, so you need to be more precise.
All right, well, then let's take it in exactly the fact pattern that we have here, Your Honor. The duty comes in at a couple of different points, all right? So if we start at the very beginning, the college, in recognition that this is a problem, and this is a foreseeable problem, has in fact created policies. So the first stage of the duty is to implement those policies carefully, okay? That means training the personnel that in fact you've hired to carry out these duties. Now, they've created, for example, they've created a code of student conduct. And the language in the code of student conduct is very clear that drinking is prohibited. Drinking by underage people is prohibited. They can't even be in the presence of alcohol in most cases. Serving them with alcohol is prohibited. And furnishing, the language that's used in the code in Section 7 basically is similar to the language that's in General Laws, Chapter 138, Section 34, about furnishing a place where alcohol can be misused. So the first stage of the duty is, if you have these policies, and virtually all schools do have these policies because the problem is that foreseeable, implement them properly, train your personnel.
What evidence do you have that they didn't do that?
I'm sorry, Your Honor?
What evidence do you have that they did not
We
actually?
have the testimony of the RAs themselves on the issue of training. We have the testimony of Patrick Ward, who in fact invited Morgan Helfman to this party. Ward and Anderson, the two RAs, were both under the age of 21. They were not allowed to drink. They in fact furnished the premises, Anderson's room, where the drinking took place.
They furnished, I thought she drank beforehand. I thought she was.
She drank in
She
her-
was the only one who furnished her own alcohol, and that the RAs did not furnish alcohol to her.
This was a bring-your-own-beer party, essentially,
So
and the
fine.
RAs
So
participated.
where is it that the RAs furnished the alcohol to her?
The RAs were organizing this party. The RAs allowed drinking games. The RAs participated in the drinking games. The RAs watched as she got increasingly intoxicated. The RAs were present as she was in the bathroom vomiting profusely. The RAs had obligations to stop this exact process. Supposedly, that's why they were hired. That's part of their duties. They
They were students, weren't they?
were students.
So they got a discount on their tuition probably, or on
They got
their-
free room and board. They got housing accommodations. They got whatever.
Well, okay, let's assume that they were employees.
Okay. And even if we were to broaden that and say, well, maybe technically they're not employees under the Fair Labor Standards Act, certainly they're hired, trained, supervised, and appointed for a particular purpose by Northeastern, one of which is to, in fact, enforce the Code of Student Conduct. Not only didn't they do that here, they actually did the opposite. They arranged for this to happen. Okay? They were the ones that created this party. They were the ones.
Where among this recitation of everybody hanging around drinking, is there any role in your mind for individual agency of these young students and to make their own decisions and be responsible for themselves?
Yes, you're referring to Ms. Helfman specifically?
Both,
Your Honor?
and all of them.
Okay. Well, the RAs we're looking at as agents of the university. So let's deal with Ms. Helfman as representative of the students that were at the party. The answer is yes and no, okay? So in terms of her own personal negligence, of course she has comparative negligence. There's no question about that. The jury will decide that. What she does not have, which is essentially what the Superior Court found, is she does not have contributory negligence. She, granted, should not have been drinking, okay? And a portion of the responsibility for this, beyond the shadow of a doubt, will be assigned to her by the jury. But that doesn't bar her from bringing the claim. And that's what the effect of this Superior Court decision
I
is.
see. So you're really arguing maybe there's not enough evidence, that there's sufficient evidence just to make it through your summary judgment phase?
Well, there's certainly, I believe that there's certainly evidence to make it through summary judgment. What the jury does in terms of apportionment, of course, is a decision for the jury to make.
I want to go back to your duty argument in a moment, but as long as you're on summary judgment and the standard for a moment, assuming that you're right on either general duty or special relationship duty from the MIT case. What about proximate cause? What about that analysis in the summary judgment issue?
The foreseeability, excuse me, on it, the foreseeability is the same on proximate cause and on duty.
No, I appreciate that. I'm saying that assuming that there is a special relationship because of the issue of binge drinking, intoxication, and the prevalence of sexual assault on campus, particularly in conjunction with misuse of alcohol by younger students at a minimum. And even assuming some concerns about what the RA didn't do and what the proctor didn't do at the dorm when they went back to the dorm. Just for the moment, don't we also have to calibrate into this summary judgment analysis whether there's enough evidence on causation?
Yes, and I think, again, this comes back to that social science research, because the connection between alcohol and sexual abuse is recognized by the college community themselves. And so, again, I think it's the same, it's a variation of the same question. I would phrase it, frankly, probably similar to what Your Honor is suggesting, which is that the issue of duty should be broader, because this is a major social problem that needs to be addressed, and you don't want to say that because, for whatever reason, you may find in the facts of this particular case that the plaintiff should not, in fact, recover, and the jury may say that. That shouldn't leave the entire female college body exposed on the question of duty when this is such a widely recognized and known problem. The distinction, I'm sorry, Your Honor, the distinction, if I may, would be the distinction, frankly, of the restatement third of torts, which is to say that the duty should be brought in the question of proximate cause on these particular facts is a question for the jury, and whether or not the facts prove the case. I suggest in this case they do.
You started with Pine Manor, and
Yes.
that case, of course, looks at criminal conduct and the reasonable expectations of parents and students to be made safe in the college environment. And I get your argument that there's a correlation between alcohol abuse by young people and sexual assault. I think that's pretty clear. The issue I've got, or the question I have for you, rather, is when you run through your analysis and you say that the alcohol abuse part of this equation is basically a foregone conclusion that they can't stop it. So what's the college to do? As far as in this continuum of duty of care, when you say that every college tries to say, don't drink if you're not 21, that's a fool's errand. Kids drink before they're 21. Where does that bring you in that, when you take that into account, upon that continuum of expectation of safety?
Well, on the continuum, Your Honor, what distinguishes this case from the other cases, that the defendants have cited a number of trial court decisions dealing with this question. What distinguishes this case from every single one of those, every single one, is that in this particular case, you have the agents of the university actually participating in the misconduct. If this was, because of the concern about alcohol, because of the connection between alcohol, youth, and violence.
So obviously different case if the RAs weren't involved.
Every single one of the RAs were not involved. Here, that's why I say this is a case
And we have two very different recitations of facts, I guess, from you.
Well, but that's a fact question for the jury to
But
decide.
Only if yours is, only if the one side is supported by the record. And if it's not supported by the record, then it's not before us. Is it?
I agree, Your Honor, but I suggest that what we're suggesting to you is supported by the record.
Okay, I'm sorry, I interrupted Justice Gassi.
No, that was a question I had, Justice Link. If you, so your argument is it should have survived summary judgment because the RAs were involved.
For sure, yes. And the RAs, the involvement of the RAs, I mean, Your Honor had asked earlier, at what stages does this come in? And so the failures of the RAs by their own testimony are failures of supervision and training. Ward in particular talked about the training that he didn't receive, and that's in the record. Anderson talked about the lack of supervision by defendant Antonucci, and there's the role of Jose overseeing the whole thing. Add to that, in terms of institutional failure, the fact that the administrators in the OSCR, the Office of Student Conduct and Conflict Resolution, were aware of these failures, and Ward's immediate supervisor was aware of these failures, and nobody took any action whatsoever to do anything about it, not even to retrain these people.
Would it be the same case if a student were drunk and she was with, and usually it's a she, if she was with her assailant, and they passed by an RA who did nothing?
Depending upon her condition. So in this case, where Morgan
Does
couldn't...
that not, does that imply, I'm sorry for interrupting, but that implies to me a presumption that males are rapists, if you see a drunk woman walking with a man. Is that where we're headed?
No, I don't think you need to make that presumption, because what the rules require here, and what was not implemented here, was that if you see a student in help, male, female, in need of help, male, female, or otherwise, that you get that help. That's the role of the RAs, and that's a 24/7 duty of the RAs. When Morgan Helfman came back to the Proctor station, unable to stand, being helped in by the man who turned out to be her assailant, being unable to stand at the Proctor station, the duty of the Proctor was to call for help so the professional help could evaluate her.
What if she was helped by two of her female friends?
Same thing. The obligation is the same. I mean, you know, that may be the answer to Justice Cypher's question as to whether or not you're presuming all males are sexual abusers. You could just as easily say, perhaps, assume that all females are
So
sexual
if the
abusers.
two girls had walked her home rather than the boy, it would have also been negligence?
If she can't stand up at the station, at
I
the,
read the deposition of her. She says when she leaves the party, can stand up with.
But that's not what the
And then,
police-
and then when she stops drinking, I find the facts are hard to, you know, I went, to know the facts, I had to read hers rather than either brief. And she says she's thrown up, she's wobbly but able to stand up on her own. And, right?
that's one piece of the
That's her,
testimony.
but we have to, I take it when we're dealing with your client, we gotta look at her, what she actually said.
Well, but if you add to that, Your Honor, the testimony of the Northeastern University police who were monitoring the video, she's stumbling on the way back. She's unable to stand at the Proctor station.
She's leaning on the Proctor table, right?
She's leaning on the Proctor table, and according to the assailant,
But can you answer Justice Gaziano and Justice Cypher's question? If the the two young women walked her back, obviously we wouldn't have had the sexual assault here, but they would still be negligent?
presumably we wouldn't have had the sexual assault, and it would still be negligent because the obligations are still the same.
So, but again, back to what your client said, she didn't want the police called. She says that, and you know, I'm not making this up, I'm reading from her deposition. So she says she doesn't want the police called. She doesn't, so she wants to get back on her own with, right?
That's what she wants.
Right.
Okay? Your Honor, I had, when I was in law school, one of my professors described it this way, and I think this is the answer. When you look at the purpose of the underage drinking statutes, it's to protect the public, but it's also to protect the individual. My professor said, when I have one beer and I get into the car to drive, I'm very careful. When I have 2 beers and I get into the car to drive, I watch for the police. When I have 6 beers, I'm the safest driver in the world. I don't have to watch for anything. If she's in that kind of case, this is designed to protect her as much as it is to protect the rest of
But
us.
I'm just trying to get, again, and it relates to the question Justice Cypher asked earlier, which is the students want some autonomy. They don't want,
Yes.
and they also don't want a police state at the university. So how do we balance all of these things? The university has to take, if there's a duty when she's that drunk, they have to act reasonably, right?
Right.
Is it reasonable to have her go home with the person she comes to the party with? It may not be, but isn't that the question we have to ask? Is it reasonable for her to go home to her own dorm with a person who lives in the dorm, who's the person who took her to the party, but he's drunk? Is that what we should analyze in terms of a breach of duty, or is this global thing you're talking about?
Well, I think it's global to a point, Your Honor, and I guess here's the distinction. So on the question of student autonomy, what distinguishes this case from Nguyen is that Nguyen was a 25-year-old graduate student who was capable of and did in fact make decisions about his own health care. And that was what was before the court, and that was what the court was agonizing about in oral argument and in the decision. Here, the underage student does not have any autonomy legally to drink. Okay, so it isn't a question of can she go get a drink, can she get it here, can she get it? She can't get it anywhere because the legislature has.
Yeah, she obviously can get it everywhere because
Well,
she
she
brought it
cannot
to
get
the-
it.
She does.
And the question is she allowed to get it anywhere? Is it appropriate for her to get it anywhere? We're not talking about invading her room. Your Honor asked about the drinking that she had done beforehand. We're not suggesting that that can be stopped. I agree with you. Okay, that's why.
But I keep getting back to what the duty is, and you say it's to
Well-
implement the policies that they have, and so I'm wondering, is it an instance of no good deed goes unpunished? Should they not have any policies? Is that what you're recommending?
I'm sorry. No, that's not what I'm recommending because they have a problem that they need to address.
What is their problem?
And I'm sorry?
What is their problem? Why do they need to address it?
Unless they're willing to concede that anybody can drink or take drugs anywhere on campus regardless of anything, unless they're willing to hold themselves out to the public as doing exactly that, and I don't think that's what they want or believe, they say the exact opposite, then they have a problem they need to address, as does every institute of higher education. Within the scope of the things that they can control, like implementing the policies that they've designed, like training and supervising the people they've hired, these things are within their control, like not arranging parties to violate the very programs that supposedly they've created to prevent this
They
type
have
of
to
behavior.
know that the RAs are doing this?
I'm sorry, Your Honor?
Does Northeastern have to know that it's doing this, that the RAs are doing these things? They have to have actual knowledge that this is happening.
They have to train the RAs not to do this. They
Okay,
didn't do
suppose they
that here.
have. Suppose they've trained the RAs not to do this, and the RAs do it anyway. Are they even acting within the scope of their employment?
Yes. They are the same way a truck driver who's trained not to get into an accident and gets into an accident is acting within the scope of his employment. And here, when they learn that the RAs have not been acting the way they supposedly have been trained to act, or supposedly the way they've been supervised, they do nothing about it. They ratify the misconduct. They take no action whatsoever in response to this. And that is, again, is undermining this policy that supposedly they've created for the greater welfare.
Can I ask you, because we have to draw lines where we set a duty of care, and I want you to try to help me conceptualize this. What you've said in distinguishing some trial court decisions is if the RAs were not involved, and this was unfortunately an alcohol incident, intoxication that led to a rape, no RAs, you're telling us, well, if they didn't know about it, how can they be liable, correct? That's at one extreme.
That's one extreme.
The other extreme would be if the person was sober, showed up in an RA's room and they started playing beer pong or whatever and got drunk through the RAs. And
Correct.
then there was a sexual assault. Not this case, different. But that's another extreme. Where do we draw the line between those two continuums? You know, if the RA happened to see someone staggering down the hallway, are they now liable? Where are we drawing these lines?
Well, the RA's obligation in this case, by the terms of what they've been trained and what the policies of Northeastern are, is if you see somebody staggering around, you call for help because you don't know what the situation is.
Where in the record is that policy?
That is in the medical amnesty policy, that's in the testimony
Medical
of the
amnesty.
RAs. I believe that's in the testimony of Ms. Antonucci. I question.
And it will read exactly as you've argued it, that if you see somebody stumbling around, you need to call for help.
That if you see somebody who is in need of help, you are not professionally trained to make the determination what help they need or whether they need help. That's why you're supposed to call out
How
for
do you know when somebody needs help?
when they can't seem to walk by themselves, when they're vomiting repeatedly in the bathroom, when they're falling down. I mean, the assailant testifies that as they're walking back,
it's
she
whatever-
falls and drags him down.
So it's whatever consequence of that. If the student happened to step out in traffic, you'd say the same thing.
With the presence of the RAs, yes. Yes.
Does it matter if I'm going to the end of the brief for a second. You say that the process to determine whether this was a consensual or a lack of consensual incident was flawed. If we decide the process, whatever this review of the incident was okay, what does that do to the negligence case? Because nothing?
Nothing, Your Honor. That's a contract issue, a separate issue.
Well, but if the
Contract in Title
university process determined that we can't figure out whether this was a totally consensual or not a consensual activity, that doesn't matter here because it affects what happened, right? I mean, we don't know what happened.
Correct.
We know but if the university process, and also there's not a criminal prosecution here, so it doesn't matter at all?
As I understand what Your Honor is really asking is whether the university disciplinary process would be res judicata on the issues of...
No, I'm not saying that. I'm just saying that the process, if it's fair, I'm not saying it is or it isn't. If it's fair and it's determined, we can't figure out what happened in here. They were both drunk, and it's very confusing of whether this was consensual or not. You know, we can't assume we have a sexual assault when we're analyzing your negligence case either.
No, that would be a question for the jury to decide at that point.
Back to the issue that one of the judges asked earlier. So if what happened was a consensual experience at the end, it's still negligence to let her walk home with this boy, in your view?
It's still negligence, Your Honor, but I guess that's the proximate cause issue that I may not have picked up on earlier. And so if the jury were to find that there had been no sexual assault,
Right.
then there's negligence, but no proximate cause. Now, I apologize for not understanding the question the way Your
Negligence in
Honor.
the air will not do.
I'm sorry, Your Honor?
Negligence in the air will not do.
Exactly. If that's what the jury determines, then
So it's a jury call.
Yes.
The jury has to make a determination in all of this, whether it was a consensual activity or not.
and that's why I said the determination by the Student Conduct Board wouldn't be binding on that issue, and that's why I say it wouldn't affect the negligence.
I have a factual question to ask you. I know that there is a reference in the briefs to her having texted on her way home, or way back to her roommate. And there's also some testimony by her that she texted again when she was in AG's room. Do we have those texts?
Yes, I think they're attached to the police report.
Okay, and so the police actually did
Yes.
examine those texts?
Yes.
Okay. And I guess my final question to you is, what does it look like if Northeastern had a duty to her, to your client? What would Northeastern have been required to do here that it did not do?
In this case?
Yes.
At different stages. If we go to the night of the event, the event shouldn't have been held in the first place. The RAs should have not allowed the alcohol to be brought in. The RAs should have carried out their obligations to report the misuse of alcohol, to intervene to stop it, to, if necessary, call Northeastern University police for help if in fact the students were uncooperative, but to stop it right at the outset. Going past that, having failed in that duty, when she is violently ill in the resident assistant's apartment, to call for help. Now she's vomiting repeatedly.
Call the police for help.
Call the Northeastern University police for help. Yes, that's what the RAs are trained to do. That's what Patrick Ward testified. I believe there's a footnote in the brief giving the citation for his testimony on that point. And the proctors have the same obligation. And what the proctors and the RAs, they're the same people essentially, are taught is you are not qualified to make that determination. That's why you bring in the professionals. The Northeastern University Police Department are the professionals to address that. Bring them in, let them make that call. They didn't do that. Backing up further in time, before the night of the party, Ward testifies that he didn't understand that his obligations ran 24 hours a day, 7 days a week. He didn't understand that his obligations as an RA ran when he was outside his jurisdiction, if you will, outside the properties, the buildings to which he'd been assigned. His obligations, in fact, ran that way, and all of the administrators so testified, and the document would seem to say as much. He testified that the training program was revamped the year after this happened, and then he did understand. Ms. Anderson, the RA, testified that her relationship, her supervisory relationship with her supervisors, was not very effective with Ms. Antonucci. She, in fact, Northeastern produced none of these training documents, none of the supervision documents. But Ms. Anderson produced them at her deposition, and one of the documents she produced that I questioned Ms. Antonucci about was an evaluation form that the supervisors are supposed to fill out with the RAs. Ms. Anderson filled out her portion of it and gave it to Ms. Antonucci, presumably, kept a copy for herself. Ms. Antonucci never filled it out. She never evaluated her. There was no evaluation that entire year. There were no reports back to the supervisors. And when the administrators found out what happened here involving Ms. Anderson and Ms. Ward, they didn't feel the need or didn't report back to the supervisors.
Okay. Anybody else? Anything else?
Thank you, Your Honor. And
Thank you.
unfortunately, we have to rest our brief on the other issues. Thank you.
Mr. Lapp.
Good morning, Your Honors. May it please the Court, my name is Darrell Lapp. With me is my colleague, Katie Garino-Baker, and we represent Northeastern University and the several individual Northeastern employees who've been sued personally in this case. The Superior Court here got it right. And the way that the court did that was by applying what we suggest are well-settled principles of Massachusetts law.
Are you saying you don't have a duty at all? A special relationship, a duty arising from any special relationship? You don't say, clearly, after Nguyen, we recognize that there is a special relationship of some sort between the university and students, don't you think?
I would submit, Your Honor, that in cases like Nguyen and Mullins, this court has said that a special relationship can exist between a university and its student in particular circumstances. But clearly, what this court has also said in Mullins and Nguyen is that the university-student relationship is not per se a special relationship. A university does not owe a duty of care to its students in all circumstances. This court said that specifically.
Not in all
Nguyen.
circumstances. How about in circumstances where there's a correlation between, a well-recognized correlation between underage drinking and being sexually assaulted?
The university has no special relationship duty in those circumstances, and that conclusion is consistent with precedent that is in the context of student drinking cases as well as in
Massachusetts?
And I would submit that that is true, Your Honor. That what this court has said in Nguyen is universities have a duty to their students fundamentally in two circumstances: where the harm arises from an issue in relation to an activity that the university itself sponsored, which is obviously not the case here with this private party.
This is, I mean, let me take this hypothetical. If the RAs are having a party, the RAs are responsible for the relation, they're dorm advisors, right? Culture of the dorm. They have a party, they bring the alcohol themselves, they get the student drunk and sexually abuse them. I'm not saying these are the facts of this case, but if that happens, you're telling me that they don't owe a duty? The university hasn't violated a duty to the students?
Well, this is not that case in three different...
But you said there's no duty in relationship to drinking and, sexual assault. But isn't that an overstatement? At some point, the university has a duty to act, don't they, and protect the student?
The university has no duty in a situation like this, where it is undisputed.
But try my situation for a second. The RAs have the party, provide the alcohol, and an RA sexually assaults a freshman.
I would submit that the university would not be liable for an assault by an RA unless the university had reason to know that that RA posed a specific threat of harm based on some prior conduct or reports of concerns about that RA, that assault would not be legally foreseeable, and the university would not have a duty to prevent it in those circumstances. And obviously, Your Honors introduced different facts in saying the RAs provided the alcohol and got the student drunk, neither one of which is...
I'm just trying to do what Justice Gaziano was talking about. Where's the line here? And it seems bothersome that that the university has no duty whatsoever. Basically, you're saying in any circumstances, unless they put sort of a sexual predator in charge of, you know, the dorm to do anything. It just seems there's got to be some duty. It's short of that.
A duty can exist when a university puts a student in harm's way, which is not this case. A duty can exist when a university undertakes a voluntary undertaking on which a reasonable student can rely, and as a result of that reliance is put in harm's way. That's what happened in the Mullins case. We're not saying that a university can have no duty to its student in any circumstance. We're not saying that a university can have no duty in relation to an assault of a student in any circumstance.
Isn't that the reliance, though, that when I send my kid to school, I rely upon the RA system, that they're not going to go into the RA's room, not your case, but play beer pong and then walk out legless into the street?
The Massachusetts law has been utterly and completely consistent on the fundamental point that adults who drink are the ones who are responsible for the consequences of their own drinking. And that has been a fundamental principle.
We have dram shop cases, there's limits on everything. We have dram shop cases, and there's issues about that would have to be litigated, whether the RA is or isn't an agent, employee of the university. Those are all complicated questions. But when you get to the duty issue, the amicus brief, first of all, talks about what we've been talking about, the relationship between alcohol and sexual assault, and the percentage of women at universities who have been victimized by sexual assault, and the amount of those that involve alcohol. That this is like hazing. Everybody should understand there's a major problem going on here. Just like universities have recognized there's a major problem going on with hazing. And in a minimum, the gravamen of the plaintiff's complaint at a minimum is, well, then at least follow the procedures that you've implemented to address the issue. And isn't there at least a duty with this known risk to implement the procedures that exist?
Well, I'd answer that question in two ways, Your Honor. First of all, we disagree that the record contains any evidence of a failure to follow procedures as it relates to the liability of Northeastern and the individual defendants who have been sued in this case. There's no evidence that they were aware of any inadequacy in the training of RAs or anyone else. There's no evidence that they were aware of
Your brother says that, and I haven't read these particular policies, but he says the medical amnesty policy and other policies that are in our record are going to show that when you have an very intoxicated student throwing up, they got to call the police. I suspect that's an overstatement, but what are we going to find from your perspective on the obligation when you're confronted with that situation in these policies?
I think you will find in the record, Your Honor, that there is evidence that if an RA is of the view that a student is in peril or may be in peril, an RA is encouraged to call campus safety, campus police to assist in that. What we have in the record in this particular case...
They're only encouraged? Wow, so if the RAC... it would be really nice if you actually track what they are supposed to do. What are they supposed to... Is that really what the language says? If an RA sees a student in peril, they're encouraged to call the police, as opposed to they should call the police.
Forgive me, Your Honor, I don't have the language of that specific policy in front of me. But even if it says, thou shalt call the police, we have in the record in this case direct evidence from the plaintiff herself of what she would have done had the police been called. First of all,
That's what she thinks would have happened, but that doesn't mean that that's what should have happened.
well,
The fact that she doesn't want it to have happened doesn't mean it shouldn't have happened anyway.
she's saying, Your Honor, I think I can answer your question, that she's saying if the police had been called, if police had been brought to see me at the proctor's desk, I would have told them, I'm fine, I'm here with my friend, everything is well and good. Unless this court is prepared to say that the university's duty in those circumstances, whenever a student is intoxicated, even when they say they're fine, even when they're in the presence of their friend, even when they're in a place that no one has any reason to believe they're in danger of assault, the university must take that person into custody.
I guess what I'm trying to do is figure out what kind of responsibility you do have. Because, I mean, it seems to me that Northeastern is trying to distance itself from the resident assistants as if they're not part of Northeastern's process, when that's simply not true, right?
There is all the difference in the world between what the RAs should do and what Northeastern should do and what Northeastern in fact does to try
And
to
Northeastern
address
is
this
different
problem.
from the RAs?
And well, if I may, Your Honor, there is an enormous difference between what Northeastern should do institutionally, which is try to address this problem and take steps to prevent it, and what the RAs should do in a particular circumstance. We can all agree on what reasonable people should do in these circumstances to try to reduce the risk of harm. But what one should do and what Northeastern does do is a very different question than whether there is a legal duty and whether there should be liability in circumstances such as this case. And it would be a perverse result indeed if the outcome here is that Northeastern is found to have a legal duty because it tried to work on this problem. It put RAs in the
How about assuming a duty, which is one of the things we said in Mullins, was a way of imposing a duty?
And what this court said in Mullins, Your Honor, is not that assuming a duty is enough. It's you have to assume a duty, and there has to be reliance on the part of the plaintiff on that assumption of duty and harm that results. What was assumed in Mullins was a duty to provide physical security with respect to a student's dormitory room on which a reasonable student could rely. And because of the student's reliance on that undertaking, that's how a duty of care could be found in that case. In this case, we have no reliance on the part of the plaintiff that Northeastern was going to prevent her from drinking. In fact, she was determined that Northeastern was not going to.
I'm having a problem just separating out what happened in this case from the general duty was supposed to be. Is there a duty generally on universities that would be imposed on Northeastern as well? Is there a duty here between a university and a student? Is there a special relationship between them enough to impose a duty?
Not in the circumstances of this case.
And you just want to limit it to this case, which is my problem. And when, we articulated something more general than that. Are we not going to?
Respectfully, Your Honor, I do think the court ought to decide this case, not some other case. But if the court is
In
interested,
the process of doing that, maybe we need to articulate something more general.
sure. And the principles that this court has already articulated and should reaffirm are the principle that the university-student relationship is not per se a special relationship. The court should reaffirm the principle that universities have no legal obligation to supervise the social activities of their students.
Including illegal activity.
Including in illegal activity where it is the student's own conduct which is alleged to be the cause of her own harm. This court should reaffirm the principle that insofar as this is a case about harm from drinking, it is the person who is in a position to avoid that harm, the adult, the 19-year-old adult.
Who is illegally doing it.
Understood, but this court has said in case after case that the statutory rule that we're all familiar with, that the legal drinking age is 21, is completely different from the question of where is the duty, where is the liability in tort. And this is true in the dram shop cases, it's true in the social host cases. Manning versus Noble was this court's decision in which the court said it is the person who drinks who is responsible for their own harm.
Yeah, but you know what bothers me about this? I've got to tell you. So the plaintiff, it's on her that she got drunk, and obviously she shouldn't have. But it's not on her that when she got drunk, in the light most favorable to the plaintiffs, that she got raped. You know, she's responsible for getting drunk. She's not responsible, let me finish, if in fact the plaintiff's recitation of the facts is accurate, to being raped. And so the issue is not whether or not the university has a duty to protect people from 18, 19, 20 years old from getting drunk when juxtaposed against personal integrity. The issue is whether you need to have something in place that addresses when somebody's incapable of consenting, not intoxicated, incapable of consenting, whether or not there needs to be some responsibility on the university, some duty on the university, like the proctor sees this person in light most favorable to the plaintiff, not intoxicated, but incapable of really being able to make appropriate decisions, and whether they need to intervene based on that duty.
Couple of points, Your Honor. One is there is no evidence in this record from which it can be concluded that the plaintiff was incapacitated. And while the court must view the evidence in the light most favorable to the plaintiff, the court need not, should not, indulge the conclusory statement that this person was...
Well, the case is over if there's no evidence of that, because consent means a reasonable person would believe they're incapacitated, although the plaintiff's whole point is that she was incapacitated. If she's not incapacitated in the light most favorable to the plaintiff, then she can, by definition, consent.
Well, again, Your Honor, the record is not that there is no evidence from which it could be concluded that this plaintiff was incapacitated. What she would like Northeastern to have done, and what she would like the courts of the Commonwealth to do, is to equate intoxication with incapacitation.
I didn't get that at all. What I got, and I can't say I'm completely familiar with the record, to say the least, but what I got was that the plaintiff's position is that she was incapable of consenting, and that means a reasonable person would understand that they are incapacitated.
Well, and again, respectfully, Your Honor, that's not what the record shows. The record, and I should emphasize, the undisputed record shows she was able to walk back across campus. Yes, she was intoxicated. Yes, she was very intoxicated. She was able to walk back across campus.
Are you saying that the plaintiff's not saying that she was unable to consent?
She is, that is exactly what I'm saying.
Well, I read what she describes goes on in the bedroom, and it's tricky. It's not as black and white as you're saying here. She describes not being able to express herself. She's so drunk. Then she goes and throws up some more. You know, this is going to be a jury call, that issue.
She describes herself as being very drunk. She never describes herself as being unable to understand what's going on around her. And what she says very specifically about the sexual encounter is, I didn't tell him to stop because I didn't want to hurt his feelings. I didn't tell him to stop because I was concerned about what might happen to my safety if I left. The evidence is not at all close on the question of incapacitation, but let's assume it was. Let's assume that she was incapacitated. Again, this court can apply well-established principles and conclude, and should conclude, that a university has no obligation to protect a student from an assault unless it involves a negligent security claim like we had in Mullins, some facilities issue for which the university is uniquely situated to be in a position to avert the harm, or unless there is some reason to foresee an assault by this particular assailant. And we do not have either one of those factors.
That's just an overreading of... Nguyen involves suicide. One of the points we made was that if the university is observing the kid is about to hang himself, they have to do something, right? It's not... And the question is this comparable? I'm not saying it is, but we've got to ask ourselves is when they're seeing a child, a 19-year-old student, not a child, a 19-year-old student drunk and incapacitated, or very drunk, throwing up, and vulnerable. Do they have to do anything? You say no. That's not decided by our case law, either way. We've not confronted this level of vulnerability on a university campus in the context of drinking and sexual assaults. We've just not done it yet. We've got to decide that issue, don't we?
It's absolutely correct that this court has not decided this particular case.
Well,
But
more
what
than
this
that,
court,
we haven't dealt, you just want to narrow Nguyen and Pine Manor in ways that we may do so, but we have not done so.
I would respectfully disagree on it. I would say I'm not asking the court to narrow Nguyen and Mullins. I'm asking this court to apply the clear language of Nguyen, Mullins, Kavanaugh, the case involving the assault of a student athlete at Boston University. In each one of these cases, what the court has done is said, students at colleges and universities are fundamentally adults. They're fundamentally responsible for their own safety and well-being, and we are going to hold universities liable where the university is uniquely positioned to avert the harm, where the university put the student in harm's way, which is different from rescuing a student from being in a position of harm. And it's important, I think, to emphasize.
So there's the rescue issue. So even though they have this part, I don't buy the plaintiff's argument they furnished the alcohol, but they've hosted the party. And the 19-year-old student is drunk and wobbly and walking back. There's no issue of, rescue may not be the right word. They don't have to take any action to protect that person. To me, it's like I'm trying to understand, do they have any lifeguard responsibilities here? They've got somebody, vulnerable and in some trouble out there. They don't have to do anything.
They have no information that this person is at imminent risk of harm. Is there some general notion that people who are very intoxicated might be subject to some harm that happens? Sure, but that sort of general abstract foreseeability.
Really? On college campuses, a very drunk 19-year-old is where we don't have any concerns that they may be in some danger out there,
I'm saying it is. Can we agree that it is generally foreseeable that if you have a very intoxicated 19-year-old student on a college campus, something bad might happen to them? We can all agree on that. The question was asked, what if this person stepped out into the street or in front of a Green Line trolley or choked on something? All manner of things can happen.
and killed somebody.
The general foreseeability that some abstract sort of harm might occur is not enough to create a duty of care. You would need to have some specific facts on which.
How about changing it so that the university provided a party, for example, which they knew that there was going to be alcohol served, including people who were underage? It furnished the alcohol. Does that make any difference?
That could certainly make a difference. That could fall within the construct of Nguyen, where the court said that a duty could occur in relation to activities that the university sponsors and controls. That's not what.
I understand, but I'm just asking you what, in terms of duty, is that a duty imposed upon a university in those circumstances?
It could, I think, depending upon the other facts of the case, although I would again revert to the point that if the harm was the result of a 19-year-old's voluntary consumption of alcohol, this court has never held an employer or any other institution responsible for harm in those circumstances.
Counsel, can you tell me what the trend is in other states with regard to this issue?
The trend is consistent with the position that we have taken. We have cited in our brief that cases in other jurisdictions are consistently to the view that there should be no duty in circumstances such as this, whether you look at this as a case of harm resulting from a student's own intoxication or whether you look at this as a case of an assault, or thirdly, and perhaps most importantly, if you look at it as the confluence of those things. There are any number of cases in other jurisdictions which we've cited in which courts have said the fact that a student became intoxicated and an assault resulted does not create a duty of care on the part of the university, and that's without regard to whether the victim of the assault or the assailant is intoxicated.
Your brother says that the one difference in the facts here is the RAs hosted the party and contributed to the drunkenness. What's your response to that?
My response is a couple of points, Your Honor. One is it is undisputed that the RAs here did not provide the alcohol, which is a key factor under this court's precedents, and as recently as the Giuliano case, this court affirmed that merely being in control of premises as opposed to providing the alcohol and serving the alcohol is not enough to establish liability. This court specifically said in the Giuliano case that the statute, Chapter 138, Section 34, that my brother alluded to, does not have a private right of action and does not create a basis for
Right, but
civil
are
liability.
the tort cases out there, is he right that when we, because, you know, we got all those smart young people who are going to go read all these cases next, so are they going to find any cases like this where the university's representatives, whether they're their employees or not, are part of the partying?
They are, and they're going to find cases in which it's held that the university is not liable
Which
even
cases
in
are those?
those circumstances. Those cases include there's the Third Circuit case, Bradshaw, in which university funds were used to purchase the alcohol. I think the Eighth Circuit decision in Friedman is on this point.
And in Bradshaw, do they find no liability or do they find liability?
No liability. I'd also direct the court to the Eighth Circuit's decision in Freeman versus Bush, in which an RA was involved in the drinking, and also Beach versus Utah, which is an interesting case in which a tenured professor at the university was present and involved in the drinking, and the court found no duty as a matter of law in that circumstance. So it would be quite a departure, I would submit, not only from this court's own precedents, but also from a well-established body of law across the country to find a duty of care in the circumstances of this case.
Anything else?
Thank you, Your Honors.
Thank you.